Carol, I'm trying to turn off my phone, so stop turning. All right, I got it. Hey, everybody. Matt Hill with Carol Ponton, another VA Benefits Questions Live from Hill and Ponton. I never seem to get that one right. Branding's not my thing. We are excited to be here. Always excited to learn from y'all and hopefully share some information that works for you guys as well. Carol has her corner set up. She's got some information she wants to share. I don't think she's going to be as angry as last time.
No,
so it might not be as
not
fun.
if y'all have straightened up.
Oh boy. Okay. Well, let's jump in then. See where the questions take us. Thomas, I was diagnosed with PLMD, periodic leg movement disorder, during my VA sleep study. Filed a claim and went to VA C&P exam, and the examiner said I had an erroneous diagnosis. My claim was denied. Has anything like this ever happened to any of your clients, and how do you correct it? Thank you. Yes. This happens. We see it all the time in mental health disorders. They've kind of cleaned this up, but when it comes down to it, what I would want to know, Thomas, is what are you actually diagnosed with? If they're saying you have no diagnosis at all, then we need to take the word of the sleep study versus the C&P examiner that saw you for 5 minutes, because that's questionable to me. If they're saying you have a different diagnosis, then their analysis is incomplete, because they have to take that different diagnosis and see if that is secondary to one of your service-connected conditions or if that is primarily service-connected. So it doesn't seem to me like this was an adequate C&P exam, or at least adequate reasoning on the grade decision.
Right. And I think you should file a higher level review and you might want to ask for a hearing instead of doing a CAR, so you can explain to them, here's the documentation where I was diagnosed with this. I want a C&P exam where the examiner even knows what that is and can say whether or not it's service connected. Okay. I think you need to point out exactly where you think they made the mistake.
PT, I'm 90% and 100% with TDIU. Can I still apply for secondary sleep apnea for my bronchial asthma, service connected? Yes. Yeah, I mean, I'll give them straight 100 or...
Yeah.
Yeah.
Well, it depends on how I got the 90.
That's true. Misambiguity. It's not ambiguously good to see. We are excited that you're back. Would you consider sleep apnea a gateway service connection for high blood pressure, for DIC, contributing factor to death? Also, could stress anxiety be considered a gateway contributor to death for DIC? Can you give us the cause of death? I would say yes to all those things. Yeah. High blood pressure is not a diagnosis as far as the VA is concerned. Hypertension would have to be the diagnosis there for that to be a contributory cause. But if you could tell us what what he died from, then I think we could be a little more useful.
So just for an example, one of my clients had PTSD, died of a heart problem, when we showed that he had high blood pressure. So we connected the high blood pressure and the heart problem to his PTSD. His blood pressure went up when he got upset. This caused the heart problem. So even though he wasn't service connected for either one of those at the time he died, we were able to allege that and prove that. And there are medical treatises out there that support this. So that goes along with what you're saying. We just need to know, what did he die of, to be more specific.
Tracy M, part 1 of 2, I was denied VA disability for hiatal hernia and GERD, citing obesity. I filed them as secondary to depression, linking them through stress binge eating. I also have a back injury in basic. My denial letter states I was overweight and obese upon enlistment, 5'9", 194. I was quite muscular. I'm unsure how to proceed, as my only evidence is a picture of me in uniform.
Can you go back to 1, Nate?
Letter states. I mean, yeah, you go ahead.
Okay, I've not gotten GERD secondary. I've gotten GERD secondary to depression because of the medication. I've never got a hiatal hernia secondary to depression. I'm not sure how I would do this. Back injury. The back injury could have led to the hiatal hernia, weakening your body. I'm not sure, but I think I'd emphasize more of those than the obesity. I think, look at the medication and see if it can cause GERD. A lot of the medications can for depression. Also, a lot of the medications that you take for your back can cause GERD. The hiatal hernia, I'd be more likely to put on my back, that because of your back, your muscles are weakened and it allows for a hernia to develop. I really think I'd go more along those rather than obesity.
Well, GERD could be caused by obesity, don't you think? I mean, I think it was.
Yeah, it could, but I think I see it so often in people who take medication for depression or for their back. Mm-hmm. And I think the VA, remember, you want to do something the VA hasn't got this big red sign, don't approve, don't approve. They hate obesity. And so they're going to fight you tooth and nail. That's why I like to go where things that I find there's medical basis for it, and the VA doesn't have this big prohibition about granting this. That's the same thing with sleep apnea. If you have sleep apnea because of a PTSD or a mental problem, there's the big red light. They're not going to grant it. You have to go to the BVA. If you can show that the sleep apnea has come from another cause, they're far more likely to grant it, because the CMP examiners and the raters have not been told you can't do this. So that's my suggestion to you. Don't play their game. Come in through things that they are more likely to approve.
And as far as the second part, had a back injury in basic. Let's go to part 2, guys. Denial letter states, I was overweight and obese upon enlistment. Okay. For them to say you're obese at enlistment, the enlistment exam, the doctor who saw you has to say that. They don't get to just make a medical finding on their own that you were obese because you were 5'9" and 194, especially from what you said. You're 5'9", 194 because you had muscles, which obviously are a lot heavier than fat. So they don't get to say that unless it's on your entrance exam. If it's not on your entrance exam, which I bet it isn't, then they have to show through clear and convincing evidence, I believe, that you were overweight beforehand, and that's why they're not awarding it to you. That's a high burden for them, a hurdle for them to get over, not you. They have to get over that. What I would do is submit that picture of you and any statements from friends who knew you before service or right when you got into service. Hey, he was really into weightlifting. Hey, he naturally put on muscle a lot. He looked big, but he looked muscular. So I would have stuff of that, because I think that's really that's a low blow, and it's illegal under the presumption of soundness there.
And I don't think it relates to the claim. Okay. Yeah. You didn't claim you were service connected because you were obese. You claimed that you were service connected for your back because of something that happened in surgery. I mean, in service. So I would also say that there's a duty to assist because they failed to specifically address your claim.
Tino, my husband has COPD and emphysema. Has never smoked a day in his life. He was on a destroyer working in the engine room, caught fire. And all the fire blasts caught on fire back in the mid-'80s, and they're saying that it's not service-connected, which makes no sense to me. He was in the Navy. Tina, we're with you. That makes no sense to us either, other than that they are just going to deny to see if y'all go away. You're probably going to need...
You're going to need a Nexus statement.
Doctor to give you a Nexus on this, pulmonologist. Those facts make sense to you, make sense to us. I mean, it's kind of a connecting the dots. Fiberglass in the air, burning fiberglass in the air, not good. But the way the rules are written for a Nexus here, I definitely think you'd want to see if his pulmonologist would connect those dots.
I think you have a very good claim.
Yeah,
I think these are typical claims. Even if there wasn't a fire, being on those destroyers and those ships caused enormous breathing problems.
The air is right. Yeah.
Yeah. They have asbestosis. They have all sorts of things in their toxins. So you have a good claim. You just need somebody to help you support it.
Connie, part 103 rated 60% for the heart. Service disability sole cause of unemployment. TDIU denied under high level review without development or referred for extra scheduler. Does TDIU require an extra scheduler referral with the scheduler criteria of 60% has been met? No, you've done your homework. Should supplemental appeal with additional evidence contest extra scheduler requirement, or lean into evidence for ES? I'm not sure what ES is. Extra scheduler. You do not want to go the extra scheduler route. It takes
and you don't have that.
Yeah. First of all, kudos to you. You clearly have read the regs. 38 CFR 4.16.
Show off.
Well, I mean, that's what's at the issue here. And if you look at that, there's quite a few different combinations to get IU through one disability. You've read that. You've got that. Apparently, whoever rated your case does not.
Yeah, I would think
Carol would say go direct board.
No, Well, I don't know what evidence you have supporting that. I would go to a car higher level review.
No, she had a higher level review.
She did?
Yeah.
Then I would go direct to the board if you have evidence, because 60%, that's the basis for TDIU, is one rating of 60% or combined ratings of other things of 70 with a minimum of 40 for one. You fit that perfectly. It's whether or not you have the evidence, and I don't know what's in there before I go to the board. I'd make sure I have that.
I'd want to go to the board for a state. I mean, at bare minimum, the board to, even if you get denied or gets remanded, but the board is going to say, no, this is not an extra schedular case. You do not want to be stuck in that loop. It is worth going up to the board and that being the only thing you get from them, even if they don't grant it, but they say, well, clearly the 4.16A applies to you. This is not extra schedular, but you don't meet it because of this, or you need more evidence or whatever, and they send it back. That's fine, because if you get stuck in this loop at the regional office, 4 to 5 years minimum.
Yeah, don't do that. I mean, we do that, but only when we have to.
Yeah, like a migraine or something, to where you're maxed out at 50.
And by the way, those are fabulous cases. I had a guy who I think had a very severe.
What are fabulous cases?
The ones where you have extra schedular. I had a guy who had only a 30% rating for his back. He didn't have radiculopathy. I think they far underrated him. But the BVA went back 10 years to when he was only 30% rated, and a combined rating of 30%, and gave him unemployability because he hadn't been working. And this was 10 years prior to when they upped the rating so that he actually met the TDI requirements. So if you have not been working and you didn't have the 60% for one thing, or combined rating of 70 with a minimum of 40 for one, then make sure that you are filing for, and I would call that an open claim. An open claim that this case had to, by the regulations, be sent to the central office. Central office is going to deny you. But one of the things you want to get from the central office is the memo. So when it goes to the central office, the person, I think her name is Betty, I can't remember. Anyway, the person who makes a decision has someone do a memorandum. And often the memorandum says you're entitled to the extra schedular TDIU. Well, she ignores that and denies your claim. But I'm telling you, as soon as you get to the board, they immediately grant it. So those are fabulous claims. If you have one, don't let it go.
But for you, Connie,
you don't have one.
No, you've got a better.
You've got a better claim.
You've got a faster claim.
Right.
That's what I'd like to say. And that you meet that scheduler, they can grant it at the regional office. They can grant it at the board.
Right.
They don't have to go to the central office. So don't, what Carol's talking about is last resort. If we have to go extra scheduler, we will. But having our clients wait 4 to 5 years is not what we want to do. So. Tina again, what would you think about caregiver support program with stipend through the VA? Because my husband is 70% service connected and getting passive care at home, and I am his home care provider. Why does the VA not tell veterans about this program?
Ooh, put it on the list. Why does the VA not tell them a lot of things?
It's money. It's a lot of money. So if he needs help every day with one of his activities of daily living, bathing, eating, dressing, medication, doctors. Yeah, if you can show that you're doing one of those or a couple of those every day, then yeah, he should get that. Now, this is a little confusing because in this show, we mainly talk about the Veterans Benefit Administration, which administers benefits, service-connected disabilities, even pensions. This, you have to apply through your local clinic or hospital through the Veterans Health Administration. Right. They're the ones that administer that. So, why don't they tell people about that? That's a bee in our bonnet as well. But,
and remember, when you apply, you want to make sure you submit to the caregiver program all of the medical evidence that you think is helpful, because they just pick what they want. And it may be only things that are in the VA. I think I've said this before. One time we found out they had picked things that were 10 years old, nothing newer. So you want to have submitted everything in there in case they deny you, which they're likely to do, and then you can appeal that. Okay. Don't count on them getting the evidence. They will not.
Lonnie, current rating is SMC-M. Oh, you're going to make Carol stay doing these.
Yeah.
For loss of use of both feet equals SMC-L plus 100% for bowel incontinence equals SMC-M. Can I reuse my 100% bowel incontinence to file for ANA? Why are you shaking your head? She wants another aid in attendance. I think she can. So if she could get aid in attendance for bowel incontinence,
Then she could
already
have
has it for
R1,
loss.
right?
Yeah. So yes, I think first of all, amazing work here. The fact that you could put all that together. I mean, in this office, whenever we have a claim, we all go back to the drawing board to see, what this plus all that works. So the fact that you've done this is very impressive.
You want a job?
So I would go for that.
Yeah.
If you can show that the incontinence, you need
Oh
the
my
help from
God.
someone else.
Yeah, I think that would be easy to show. Just detail a day of what you have to do.
Yeah. So great job there.
Excellent
Let us
job.
know how that goes. That, and again, as Carol talks about, these are big benefits. What's M? 7,000, 7,000?
Right around there. R1 is almost 9,000.
Yeah. So these are big benefits and you deserve them. So
Yeah.
great figuring this out. And
Tax free.
Yeah.
By the way, with the loss of use of feet, I want to make sure that he was given an automobile allowance and also given the right to have his house adapted so that he could get around with loss of use of feet. If you don't have that, you should file for that. They're paying around $26,000 toward any kind of either a new vehicle, a used vehicle, or adapting the vehicle you have so that he can drive it without his feet. So make sure you got that benefit. That's another thing the VA is not going to tell you.
Right. Killmonger Jr., how many cases are generally assigned to BVA judge at a given time?
No idea.
No idea.
They don't tell us things like that.
Yeah. Muriel Morgan, I moved from hearing docket to direct review docket. When they moved dockets, they split it into 2 appeals. Both are on direct review, but 2 different docket numbers. This is normal. This is the VA.
Nothing's normal.
Yeah, normal. Normal's not in their vocabulary or their action.
Yeah. What's your definition of normal?
I
have never seen that.
No, I haven't either. The veteran's aid. If a veteran had a suicide attempt in January and still had passive ideation,
Yes.
is that enough for advancement on the VVA's docket?
What do they need? I would definitely send in the medical records that support that because they're not going to take your word for it. So I would file the motion to advance in the docket due to a suicidal attempt and passive ideation and whatever, like, did he go in the hospital? Was he in the emergency room? Were you a witness to that? Make sure you document that and it'll get moved up right away. If you don't document it, they'll hold it forever and then deny it.
Mouse Snapper. Hello, I'm 20% qualified for radiculopathy. I requested a raise because I was diagnosed with foot drop.
60%, baby.
I'm wearing an AFO brace. I've documented muscle atrophy and weakness in my foot. Increase denied. Yeah, that's baloney.
That's
if you
baloney.
have documented foot drop, as Carol said, that's 60 right there.
Just make sure you show that you have been prescribed an AFO, and documented muscle atrophy is really big.
That's frustrating. That should be an easy one for them.
Yeah, the problem is the new people are put on these initial ratings, and they remember if they deny something, nobody cares. If they grant, they're going to have this looked at 3 by 3 people. So just because you get an initial denial doesn't mean a thing. You need to pursue through the higher level review in the BVA.
Agreed. RB, I have higher level hearing coming up. CMP doc has me on lower rating than my private doc on the DBQ. Shouldn't the rating be in favor for the higher rating if one says 50%, the other says 70%? Mental health. There's shoulda, woulda, coulda, and then there's the VA.
Right.
So we gotta put that aside. Okay. There's what should be, and then there's what is. What you need to do is get a copy of the CMP exam. You need to talk about what was not done there versus your private doctor. What he asked you, what he didn't, how long was the exam versus your private doctor, how long have you known him? What did he say? What symptoms did he acknowledge that the other one didn't? Okay, so you want to kind of compare and contrast for this higher level review. You don't need to be angry. You don't need to speak poorly of the CMP examiner.
No, don't do
But
that.
you want to show how it was
Inadequate.
And I mean, I haven't even seen it, but I bet you it was inadequate. They all are, frankly, because they're just checking boxes. They're trying to speed you out the room. So that's what I would do here.
And remember, you need to put that on a 4138 because that means you have sworn what you said is correct. If you put it on a piece of paper, it gets lost. They don't pay any attention to it. Okay. But I'm telling you, in the regional office, so that's the initial and the higher level review, it is almost 80% of the time, if not more, they're going to take the CMP examiner. That's just the way that they're taught to do. Now, you have somebody who's been there for years, knows what they're doing, feels confident. They're going to go with whatever they think is right. But that's unusual. These are direct appeals to the BVA. The other thing you might want, if your doctor is helpful, is for your doctor to rebut. That would be really helpful.
Yeah.
Rebut what was said in the C&P exam.
Can't do that for a higher level review though. If you get them to rebut, I would, if this is denied by the higher level reviewer, I would supplement claim with what Carol just said on it, if that's the way you go.
And then when they grant you, remember to file for an earlier effective date, because they'll give you the date of the supplemental claim.
Yeah. So just, this kind of goes back to the theme of what we talk about here. Knowledge is power. You asserting that knowledge, asserting what you understand your claim to be, and not waiting for the VA to do the right thing. As in, the right thing here is to go with your doctor, not them, and just assume that, because they're not going to do it. And as frustrating that is, at the end of the day, we want you to have the benefits you deserve. And so you got to be ready to have your own action plan and not waiting to see what they do.
Yeah, remember, this is a game. Don't let them win. If you don't get mad, you just figure out this is how you do it, you'll win. I know my clients get so upset that it takes so long, but I say, we're going to win this claim. Just hang in there with me and you will win your claim. Just keep doing what you're doing. You're doing a great job.
Cynthia, thanks for all you do. Does VA sometimes assign 100% permanent total strategically to avoid triggering SMC or housebound? I have other issues pending and feel like the timing of the P&T was done purposely.
Well, they all do all sorts of things.
Yeah, I got 100% P&T finally. Thank you for all your help.
You're reading the same thing again, man.
No, go back. There are 2 posts here. Somebody, see? Jeez, I tell you what, guys, it is hard being on this side of the camera sometimes. Okay, so let's go to the second one. So congrats on the P&T.
That's great.
That's great to see. And I'm glad you know this. You're sniffing out what they're trying to do, how they're trying to keep your money. So yeah, they do. I think they do things like that sometimes. And the question is it incompetence or is it nefarious? At the end of the day, it's typically incompetence. But make sure you get those benefits. Okay, if you housebound and SMCS is housebound or it's statutory. If you have 100% or IU for one disability and your other disabilities combined for 60%. Easier way is that second way. So keep fighting for this, because this is another $300, $400 a month you should be getting.
So I want to make sure, did you file a claim for unemployability that would give you 100% under unemployability for one issue, and then you can use the others to get that SMCS for you. So make sure that was filed. The other thing I find when people file for unemployability is a lot of times they don't turn in the form 21-8940. If you don't turn that in, they will not even consider the claim, because the 8940, you say exactly when you were unable to work, why, and then you list your employers in the past. So make sure you have done that. Second thing, if you've done that and they ask for it again, give it to them again with an updated date. I've had my client denied because
even if it says the exact same thing.
It's same thing, but they wanted it updated, meaning since last year you haven't worked. Okay. So make sure you read what they're asking you to do and you give them everything they ask for. Don't give them a reason to deny you.
It's like a stamp denial. Yeah.
Yeah.
All right. Grace, Ibid, 16 exceptions. Statute 5110 provides otherwise, including one specifies the effective date of the award of the disability comp. Can you explain the 16 exceptions? And have you won a case from one of the 16?
Go back. What was 16?
So typically the effective date is the date that the claim was filed on this claim stream, or the date the disability was diagnosed, whichever is later. That's the rule. I can't name off the 16 exceptions, but honestly, that's where you guys get your money's worth from attorneys. Is yeah, we want to win the claim you bring to us, but what we want to do is find, did you have a prior claim that was unadjudicated? Did you have a decision that had more evidence put in that they didn't consider? Was there a Q claim? Was there new evidence? Was there evidence from service records that they had not gotten on the previous claim you filed, and we can reopen all the way back? So there's a lot of different ways here. I don't know all 16.
I can tell you that the latest one I think that's going to be in there is, remember, you file a claim and they tell you you filed on the wrong form. A lot of times they're wrong. So that's an open claim. Mm-hmm. So a lot of those, it's really hard to tell you all these because there's so many, they're so difficult. And, that's the one thing that we really work hard to find.
I mean, again, we're elbow deep in a claims file. It could be 1,000 pages, it could be 10,000 pages, but these are the things we're looking for. Usually when a vet comes to us and says, this is my disability, this is what I'm trying to get, we've done tens of thousands of these cases, and we can kind of almost eyeball that, say, yeah, the VA screwed up. But what we want to do is get as many of your dollars as possible. And so this is where we live, basically, are these exceptions. But to do it, you got to get your file. You got to see what they did when. You got to see if you can, the evidence was there then, or there's a lot of digging to it, I guess. So
okay, here's an example of this week. 1986, my client got out and filed a claim for service connection for his shoulders. He was denied. In 2016, 40 years later, he filed a claim for his shoulders.
40? That's 30.
30. I can't.
She always tries to make herself look better than she is.
So anyway, he filed a claim for his shoulders. I found that that the service medical records had not been in the file when he first claimed, and they went on and on and on about how bad his shoulders were, all the procedures he had to have. So I appealed. It has taken forever. The BVA denied opening it prior to 2016. That's a lot of times with the BVA, that's what you're going to get. Appealed it to the CAVC, the Court of Appeals for Veterans Claims. They sent it back to the BVA, and we just got him rated all the way back to 1986 for his shoulders. So even though these are clear, you ask about the exceptions, that's a clear exception. That's everybody knows that. They don't want to give you the money. And even when you go to the board, which are judges who are supposed to know the law, they act like, no, this is ridiculous. You can't do this. So sometimes you even have to go to the court, and sometimes above that. So being here, knowing you have the claim, keep with it. Okay. Don't let these go, because he just got a lot of money.
Yolanda Furs Adams, good to see you. Currently at 70% for PTSD, had CMP for upgrade, having issues with arms and legs, service connected for both hips and feet. PTSD prevents me from hiring or letting anyone in-house to help with ADLs. That's interesting. Would that be considered for PTSD upgrade, or would this adversely affect my benefits? Is there a way to get ANA without them coming into your home?
Okay, first of all, no one has to come into your home. You get aid and attendance because you need help. Like we had a person who needed help. He didn't have any help, but he clearly needed help. Okay, so remember, it's not anybody is coming in either after you win or before you win. It's the fact you need help. Okay, if you can get your doctor or other people to talk about why you need help, that would help. Also, I don't know about PTSD being higher, helping for that. I definitely would allege that. That's a very common thing with people with PTSD. So I'm not sure how to have that. But the other is service connected for your legs.
Well, let me just say, building on what Carol said, it's a subtlety the VA is not going to get, the need versus the actual having. So the example I always give is with sleep apnea, you get a 50% rating for the need of a CPAP or need of a breathing assistance machine. Well, we have plenty of vets who also have PTSD who can't have something on their face at night. So even though they can't use the BPAP or the CPAP, they need it. It's been prescribed to them. Therefore, they're entitled to that rating. And that's the same thing Carol's saying
but
here.
The VA will give them a 0%
Right.
or.
So same thing here, in that if you need help with ADLs, even though your service-connected disability is preventing you getting that help, you still should be getting ADLs.
Right.
I'm sorry. So yeah, if you fall and get seriously hurt requiring surgery because of the legs and have constant pain afterwards.
Yes.
Yes. Anything that started with those hips, if you fell and you broke your elbow, that would be secondary service connected too. But this is direct. You got injuries to your legs. Yes, pain as well. Okay, one more, and then it's that time of day. Where do you get the book that tells exposure by MOS title? You talked about this last time.
What is MOS title?
Military Occupational Specialty. Remember you were saying that?
We found it online, and I can't remember, but I'm going to make a note to make sure that we can try to put that up. Remember, with the new administration, they have taken down a lot of the reference and resources that we have. I don't know if it's still up. Okay, but I will look, and if it's still up, I'll let you know where it is.
says. Okay. It's that time everyone's been waiting for. He wasn't able to find that.
Okay.
She says she's not as pissed
I'm
off
not-
today.
I'm
So
not.
let's see if we get smiles versus finger waves.
I wanted in watching the claims that come into me and watching how claims proceed, I really want to go over again how you should start your claim and process your claim. Remember, under the AMA, they love this no claim unless you filed for it. Even though for years we have had inferred claims that say, if it's clear that you needed aid and attendance, then that's when the claim arose. If it's clear you have loss of hands or feet or use of hands and feet, that's when the claim arose. Not anymore. Anymore, they are solid. If you didn't file for aid and attendance, forget it. If you didn't file for loss of use of feet, forget it. So I want you to do this when you start your claim. I want you to think about all of the problems you have that you think should be service connected and file for them. Okay. Clearly, unemployability is something you're probably not going to get because you don't have any ratings right now. Okay. But when you are available to get that, you will have filed, and therefore you can fight to get that unemployability back to the time that you first filed if you can show you have ratings for that. This is the same for aid and attendance, loss of use of feet, loss of use of hands. Okay. So you need to realize people are going to tell you you're going to be denied, so don't file that claim. That's not the issue. The issue is establishing an effective date so that when you win, and you're going to win, you will get paid all the way back. It's really sad to me when clients are sort of piecemealing their claim and they keep filing a little by little, and then they get unemployability the date they filed it. So don't do that to yourself. The other thing that I would tell you is I have been shocked by how many things are all related. So if you have hypertension, high blood pressure, then you're likely going to have a heart problem. You know, if you have hypertension, it may cause you to have anxiety. There are all sorts of things that are related. So just because you can't relate one thing to the service, but you can relate it to another condition you have that should have been or is caused by service, make sure you file for all of those claims as well. I find if you have the disease and if you think there's a legitimate connection, okay, I don't want you to go filing for stuff clearly that didn't happen in the service. Don't do that.
Or it's not related.
Or it's not related to service. But every significant problem you have, I think you should sit down. Clearly, you're going to know some are service connected, and you should write or Google, does hypertension cause whatever the other glaucoma, any other problem you have, okay? And then you start filing for all of them. They're going to deny all except the one that causes it. Once they establish hypertension, then you can continue the claims. Then you come in and say, here's a medical treatise that says one of the leading causes of glaucoma is hypertension, diabetes, whatever you have. So that's the big problem I'm seeing, okay? You're not filing all these claims. So remember, before people would say, well, what if I get 100% for my back? I don't really need all these claims. Now, under the Berry case, it is clear that once you get 100% and you get aid and attendance, you're going to get paid for all of these other claims that have a 50% rating or higher. So you're going to go from $4,000 a month up to $5,000, $6,000, $7,000, $8,000 a month. So this is important. Establish the claim, figure out where you want to go, and file those claims now. I can't tell you how important that is. It is so sad to me when people come to me and it's too late to get unemployability, although they haven't been, it's been 10 years they've been out of work, but they never filed. So don't let yourself, y'all are smart. I'm really impressed with what you do. So this is the one thing that I'm not seeing, and I hope that all of you start doing it. And that's it. Wasn't that nice?
That was good. Let me speak to that in a different way. So Carol kind of said this, but this is a really important thing. You want to start with the end in mind. Okay. So you start by thinking about where do I want to be? Not saying, okay, I got to get this, and then I get that, and I get this, and then I finally get there. You want to start figuring out what that is. And so how nuts and bolts wise, I would think about that is file an intent to file. Intent to file gives you a year from that time to actually file your claim. You're going to want to find at that point, you got to file all your claims together once you file, but you file the intent to file. You do, as Carol said, think about what's your universe of disabilities, what is connected to service or secondary to the service connected disabilities. And then I'd ask your spouse, I'd ask your doctor, like, hey, you gave me this diagnosis sheet in your VA records, you have one. What of these are connected? and just kind of have a good understanding of what all's coming together at the beginning, and then file all those. And then with the end in mind is, hey, I should be service connected for all these. And as Carol said, if I can't work because of them, I put that in there too. So take your time. I do think that's kind of a good thing with the intent to file, is that, you're not hurrying up to file just to get the correct effective date. You put that in there, and you can be thoughtful about what issues you're putting in and why.
And the other thing I would say, unfortunately, for people who have Parkinson's, dementia, peripheral neuropathy, muscular dystrophy, multiple sclerosis, problems like that, you are going to need all of those things. You're going at some time to be out of work. You're going to need aid and attendance. You're going to have loss of use of feet and hands. So file those right away. Okay. It's really sad, but you don't have to worry about that. That's something you need. And don't let the claim die. Remember, within a year, you have to appeal it. Just keep appealing. Put in a supplemental, file a high-level review. Just keep it going so that when you actually win what you need to make those effective, you're going to get that rating all the way back.
That's what we got. I kind of like it when she's spicy. That was a little, but, can't get it every week, guys. Jay Monk, how much merit if I use case studies from medical library as another supplemental? Was already denied and have gone through informal HLR. Last, I guess it's obvious I will need to go to the board. So new and relevant evidence. If there are case studies in a medical library that are relevant to your disease or the disease process or the connection to service, yeah, submit those. That is a very low bar on what is required to reopen a case. So if you're reopening and you have that, it sounds to me like you're also going to need Nexus. It sounds like that's what's missing, is if you can get a private doctor to say something to this.
Right. If the initial and the higher level review has said there's no new and relevant evidence, don't go to the board unless you're sure there is new and relevant evidence, or they're just going to deny you too. And that's just lengthening this appeal.
Yeah, the issue on appeal there is not whether whatever you have is service connected. It's whether the case can be reopened.
Right.
So you don't want to fight for 3 years just for the board to say, yeah, sure, we can reopen the case, when really what you want to do is prove the case.
Right.
Agent 2 2017, good to see you. Hello. VA will not send veteran to previous community care cardiologist. Now wants to send veteran to a doctor an hour away. VA won't give the veteran a reason for the change. Your thoughts, please.
I would go to whoever at the nearest VA is, that the social worker, anybody up there, and ask them if they can figure out why. And maybe you can get your local doctor to say that I'm not capable of driving and I don't have somebody else to drive me. That's a 2-hour trip. And I think if you get that, then you can have a basis for having it changed. I don't know why either, but I think if you go to somebody that has the ability to get that changed, I don't know who you've been talking to, but I think first you start with the social worker. And then if you don't need work, I'd go to whoever the head is at the VA where you get treatment. I mean, I can tell you these people don't want to talk to you. So they're probably going to send their secretary out and see what they can do to make you go away. And maybe that's giving you what you want. But if you document, I have a heart problem, I can't drive an hour, and maybe get one of your doctors to sign off on it, I think that's all you really need.
I'm going to pull Carol here for a minute and say, and another thing that doesn't relate to this at all, relates to Carol's corner. One thing she said about filing all the disabilities together, you'll get people say, well, you're not service connected for the initial thing. How can you be service connected for the second thing? Or you're not service connected at all. How can you be service connected for TDIU? We've had VSOs do this to veterans who come to us, and that angers us beyond no end. If you have a VSO telling you you shouldn't be filing for, sleep apnea secondary to PTSD since you don't have PTSD service connected yet, that is nonsense. Go somewhere else. We get calls from the VA employees hot at us for doing this as well. They say, well, why are you filing all this when you haven't even proved the first thing? And you say, whatever, deny me if you're going to deny me. But don't let people, experts or people from the VA, talk you out of it. That was really like you. I mean, I just went way back.
So my mind flits all over. You know that.
Timothy, good to see you. Can I file a supplemental claim for ANA for PTSD rated 100%? Yes. If I have a live claim at the BVA for Barry half-step increase, or do I need to hold tight until the BVA adjudicates claim first? I don't know what that BVA claim is, but no. I mean, you can have multiple claim streams going at any time.
Yeah.
Brooke, if I file intent to file and get a claim denied, can I still receive back pay up until the intent to file if I submit and win a different claim, if that makes sense?
You can file intent to file anytime.
Claim get denied. So if you're filing for claim A and that's denied, and you file for claim B, claim even if it's within a year, the way VA interprets the intent to file, that only applied to claim A. I think this is ridiculous, and I think this is a law that needs, or an interpretation of the law that needs to be challenged. But if you're saying you file the intent to file, you file claim A, that's denied. Within the year of the intent to file, you file claim B and you win, it's only going to go back to when you filed the intent to file. I for one, would challenge that all the way up to the court. We haven't had that case yet, but the way they interpret it right now is that you only get one submission. It can be as many issues as you want, but you get one submission for the intent to file to be triggered. My OB. Hi, do you send clients to private doctors for IMOs and Nexus? We do. We try to use their doctors, try to use their VA doctors, but sometimes we have to use other outside docs that we've worked with before.
Yeah, the vast majority of the time, private doctors just don't want to do it. Occasionally they will, and that's wonderful because that's a much stronger report. But most of the time they just don't. I think these doctors are thinking about personal injury, workers' comp, where they know they're going to have their deposition taken, and there's going to be some nasty lawyer asking them questions and taking up their time. And I think that's why they don't do it. But remember, the VA is not going to contact this doctor. Nothing's going to happen. They're just going to send you a letter, give you the report, and that's it. But we can't seem to convince the doctors that's what's going to happen.
It's frustrating.
Yeah.
Joseph, I had Hill and Ponton for half denied TDIU, filed supplemental for TDIU, denied again at 100%. Should I stop?
I denied or half denied TDIU, filed supplemental, denied again at 100%. Should I stop? If you,
I'd say talk to your attorney.
Yeah.
Whoever's running your case, we have full faith in them. They're as good as we are. So I would, and obviously they know your file, whereas we don't. So I would say talk to them. I don't really want to second guess my attorneys because I have full confidence in them.
Yeah, me too.
Grace again, denied headaches, migraines, boot camp, hit in head with rifle, complained of headaches throughout service, 2 incidents of things falling on head, documented. It's been over 20 years. What to do? The fact that it's been 20 years doesn't matter to me. Especially if you've had problems consistently since service. I mean, hopefully that's documented in your file. And if you have a current diagnosis, the only thing then is the nexus, the connection between the two. The VA is going to try to attack and say, oh, that's been way too long. I'd want a letter from you saying, this is what happened in service. I got out of service. Maybe you didn't treat for it because you just went on with your life, but you had problems and you had them of this consistency. You had these kind of issues. So I would want not long, but just something detailing those 20 years. I mean, if this happened and you had no problems until 20 years after, it's a hard case, but I'm imagining you didn't, because it seems like you had some pretty bad trauma there. I'd also see if unfortunately there's traumatic brain injury involved there. I mean, hitting head with a rifle, things fall on your head. I mean, migraines is frankly a symptom of traumatic brain injury. So I'd be looking at that.
Yeah. And so memory concentration, do you have any problems with that? But if you have somebody who's known you over the last 20 years and can say you've complained of headaches since they've known you. And then the other thing that the VA mixes up is you have to show a continuity of symptoms. The VA also says there's no continuity of treatment. That's not the law. Okay. You don't have to show that. You just have to show this is continued. Okay. And that makes your claim a lot easier. If you can show it by a statement from yourself and from any witnesses, that makes it even better. Okay. But I think you have a good claim.
Ray, during a recent CMP exam, the examiner claimed that my podiatrist diagnosed me with plus minus. He failed to note my club feet. Could this be related to service due to 10 years as a Marine running on them?
Yeah.
I mean, again, I'm not a doctor, but that makes sense to me because you're running on them in uncomfortable boots with a pack. That definitely does not do your feet any service.
Right.
Don, will I be denied for rating for knees if obese. I have service connection and current diagnosis. I don't think so.
Nope. I've never seen that.
Once it's service connected, they own that. It doesn't matter what other happens. I mean, I have a problem. I have a guess that if you're obese, that probably has something to do with the fact that you have a hard time using your knee.
Right.
So yeah, I don't see how they do that.
Yeah, I've never seen them bring that up at all.
Samuel, I had 4 mental health exams, 2 through VA contractors, 2 through private docs. QTC completed a favorable exam last month. Why did the VA schedule me for yet another exam directly with VA again?
That's a question we ask ourselves all the time. I don't know why, but lately we've just seen this over and over and over again. I don't know if they didn't like that you had a favorable exam. I don't know if they feel like the Nexus part was not clear. I don't know if they want to delay it because they're too busy to get to it. I mean, there are all sorts of things that come to mind because I see this over and over again and I don't see any reason. They say it's not adequate. I can't see anything that's missing. So you just need to know this is a real problem with them. And we have had no ability to stop them. It's costing the VA a fortune.
Costing you time that you, frankly, they don't have, frankly, a right to defend of yours. We feel you. This is incredibly frustrating. This is just another delay, nonsensical part of the
delay, deny.
Yeah. HOLID for caregiver program is a requirement daily assistance with ADLs or regular assistance. What's the difference? How frequently is assistant required to be approved?
Boy, I've never seen anybody bring that up.
My understanding is it is daily.
Yeah, activities of daily living. Yeah.
So that's our understanding. If you have a site to some reg that we're not seeing or something else, I mean, we are not all knowing, and you guys teach us a lot. So please do send that along. But as far as my understanding, the cases I've won with this, I had to show it on a daily basis.
Right.
Cassie, it's good to see you. Do you have to have a new 21-2680 forms if you are submitting supplemental claims, or can you file a supplemental claim for aid and attendance and loss of use?
Okay, the 2680 claim is specific to aid and attendance. Okay, so you don't have to file that form. The VA is supposed to give you an evaluation, but if you can get your doctor to complete that, that would be helpful, and it has to be a current one. In other words, periodically they will update these forms, and if you put in a form that's not current, they're not going to take it. Don't tell me why it makes what's on there inadequate or incorrect, but they won't take it. So I would always download whatever the aid and attendance form is and make sure that it's current.
And the second was some aid and attendance claim was denied and want to submit a supplemental claim for the denied aid and attendance claim.
I have 3 SMC claims that were denied. I want to submit a supplemental claim for each one. Is it necessary? Well, 2680 would only be for if you have 3 SMC claims, are all 3 for aid and attendance. If not, you only need 1 2680 for the one that's aid and attendance. I'm not sure we've answered your question. So if you could let us know what specifically you're asking that we didn't reply to.
Scotty, do I need a Nexus for lower back pain? Radiculopathy was not diagnosed in service, lumbar degenerative disc disease. So we got a couple things there. Service connection, something happens in service, you have a current diagnosis, and then there's a nexus between them. The incident in service is not a diagnosis, okay? If you have a diagnosis in service, great, that helps you. If you don't have a diagnosis in service, but something happened, that's what matters, okay? So it doesn't matter that radiculopathy was not diagnosed in service. I would assume you'd need a nexus. I mean, especially for back pain, I think.
I guess we're assuming lumbar degenerative disease occurred later. If it's shown in service, then that's very helpful for getting you a nexus.
Want to go back to the aid and attendance question. I just looked this up while we're talking. It is only necessary that evidence established the veteran is so helpless as to need regular aid and attendance.
That's not caregiver. Consistent. That's aid and attendance, though.
He didn't ask. They wanted for aid. I'm pretty sure it's aid and attendance. Go back to that aid and attendance question. I think it's a couple back.
Caregiver program.
Shit. Okay. She's right. Well, still, I thought this was interesting for aid and attendance.
Right.
You don't need ADLs. Okay. Even when she reads better than I do. Jay, will the new emphasis on voluntary rating activity over time spur an increase in knee-jerk denials to give the backlog clearance facade?
What's the voluntary rating activity?
I don't know.
You need to tell. I don't know of that. I know that they are trying to set up an automatic rating so that now that they have these forms and they just click, 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 that it would automatically give you a rating. But I haven't seen that yet. Have you?
Mm-mm.
But I don't know what voluntary rating activity means.
As far as getting rid of backlogs, yeah, doing fast denials, that is right in their purview. Okay.
Yeah, we've seen a lot of that.
Caregiver standard. It had to be daily assistance, but then that requirement was actually invalidated. So the new reg says supervision or protection based on symptoms or residuals of neurological or other impairments entry. It says regular or extensive instruction or supervision without which the ability of the veteran to function in daily life would be seriously impacted. So the veteran does not need daily help to qualify for caregivers. It's regular and extensive. So
thank you. This is why we love this, because we've learned something.
Yeah, I mean, the problem is we learned the old way before it was invalidated.
Yeah.
And we stuck with that. And now, this opens up for a lot more bets. So thank you for that. Oh, we said that one. Sweet Pea, hey, is it common for the VA to send a DBQ back to the C&P examiner to clarify? Yes, basically didn't check a box. Or do they have the veteran go to another exam? Usually they send it back, they ask a question, and the vet does not have to go to another exam. Frankly, this is a good thing. One more thing. I heard on YouTube that VA was granting overtime for raters to get caught up on the backlog. Any truth to that? Do you hear that? We hear that periodically. I mean, I haven't heard in the last couple of weeks, but periodically they do grant that. And frankly, sometimes they even make it mandatory. So if they feel like they're too far behind, they are starting to get more and more backlog right now.
One of 6.
Each one of 6. Mental health. Never filed for it. Too much pride. Trying to claim now, 20 years later. In active duty records, 1 MST. Got counseling. Year later, not reported. Not rape, inappropriate touching. 2 developments. 2 deployments. Excuse me. Both my knees were denied when I got out in 06. Evidence in active duty records include right knee injury on deployment in 2000. Sick call slip. Some doctor visits, knee pain, and other on some of my physical profiles, 0304. X-rays 1 year before discharge showed that mild the osteoarthritis in both knees and was almost med boarded out. Also paratrooper, airborne school, and on jump status with unit 2 to 3 years. Don't think C&P looked at C-file light on exam. I pushed past pain with range of motion because told at exam, Rater didn't look at 2005 AO X-rays profiles, or that I was a paratrooper or MOS MP infantry duties on deployment. Appeal denied, de novo review denied, bad veteran service officer, self-treated, medicated for years, recently went back to VHA, got new X-rays, so degeneration and documented chronic knee pain. If VA PCP won't fill out DBQs in Nexus, first appointment in June, trying to find private provider, what other evidence should I be collecting right now for supplemental? Any chance back pay at first denial? Contact the DFAST for LES to show hazard duty pay, jump status. Thank you for all that you do. Okay, start with it sounds like you never filed for the MST.
Right.
So the counseling does sound like it was in service. That is a marker. That's an in-service incident. The fact that you didn't apply does not matter at all.
No.
Focus on that. Okay.
Remember, a lot of people have that. They just power through, but later in life, it comes back and it's overwhelming. So I think you have a good claim there. Your DD 214 should have on there, if you were a paratrooper, sometimes it has how many jumps you have. I would also get your military service records, because also they often have, certification for a parachuting course. Sometimes they have how many jumps you've had, and all of that is really important. There is a military study about the damage to people who are paratroopers, how bad it is for their knees, their backs, everything. If you can find that, that would be very helpful.
Yeah, and you're going to need medical nexus for all this. Okay.
Right.
I mean, this is pretty strong evidence when you're a paratrooper and you having any kind of arthritis or any kind of orthopedic problems that tracks. Now, as far as you getting earlier to the first denial, again, that the rule is no, you can never do that. But in your case, the fact that they denied these things, I'm wondering if the C file contains your full service jacket.
That's what I'm wondering.
Did they get all the records showing that you're a parachute trooper or a paratrooper? And did they get all your service medical records? So the way to find this out, what we do is we order this whole claims file. What did they get it? Or sorry, what did they get? When did they get it? Okay. Faster way, or kind of, we don't do this, but one way you can do is go back to that first rating decision, look under evidence, see what did they list as evidence? Did they list out all your service records, all your service medical records, your full service jacket? If they didn't do that, and that's just been added on this claim, then yes, you can go back to that first denial because they didn't have critical evidence to make a decision on your case. They frankly were lazy and didn't get your records. You're going back under regulation 38 CFR 3.156C. Okay. That's the reg that triggers them to have to go back. They hate that regulation. If we're talking a couple decades, they're going to deny you up to the board. But yeah, you do have a possibility to go back there.
And remember, normally what they would collect would be their service medical records, and they wouldn't get your military file. So it may be all of the information about you being a paratrooper, how often you jumped. Even if the service medical records were in there, your military records were not. So make sure you knew what they had, because that could open up the file. And remember what I just told you. You know, I had this exact same case, and they were the board refused to open it up. I had to go to the CAVC. So these are good claims, lots of money, and they don't want to do it. But hopefully you're going to be able to get that.
All right, Nate, let's do two more. Alan, Vietnam vet, been awarded 100% rating, non-Hodgkin's follicular lymphoma. My oncologist is using a wait and see approach. I'd seen P exam and disease is still active. Can I get P&T?
No.
No. Yeah, you can't, unless the doctor says that disability is going to be in an active state for the rest of your life.
That there's no cure.
We have seen that with CLL,
yeah,
CML. But if your doctor would say here, look, whether I treat it with, chemotherapy or whatever, or if I don't, it's still an active disease process, and it will be until the time you die. If you were to say that, then yes, it should be permanent total. But typically with cancers,
yeah, no,
they don't do that.
But remember, you filed other claims. I can't believe you have non-Hodgkin's lymphoma and don't have depression or anxiety. You know, maybe you have erectile dysfunction. Maybe there are other things that it's caused. Please file a claim for that. Also, aid and attendance. The cancer can be exhausting. You're fatigued. You can't take care of anything. You need somebody to take care of you. You may have chemo brain where you can't remember your medications, go to the doctor. So file for aid and attendance, file for mental if you have that, erectile dysfunction. Are you getting all the benefits you're entitled to? Has it caused other problems? Sometimes this can cause a heart problem or high blood pressure. So figure out what you're diagnosed with. Google, can non-Hodgkin's follicular lymphoma cause that? And if it can, file a claim. It can clearly cause depression, need for aid and attendance. This is what I mean about really developing your claim.
All right, last one is from Marvo. 1 of 2, effective date question. Granted 70% PTSD with TBI on BBD claim with effective date of 1 October 24, overall rating 100%, P&T, submitted increase and was granted 100% PTSD with TBI, special monthly compensation S with effective date of 1 January 25. How do I get back to the initial claim of the BDD claim? It looks like I should have done a supplemental claim instead of just an increase. What's my best argument at higher level review?
I think, they clearly didn't.
It was within a year too.
Yeah, so it's within a year. It's an open claim.
Supplemental or increase, it doesn't matter. It was an open claim. So you need to say, look, all of this took place. And I mean, frankly, if you got out, it should go back. Yes. So just say, look, this was one continuous claim.
Yes.
And it should go back. So yeah.
But this is typical. Remember, we talk about this all the time. If you file a supplemental claim, but you're appealing a prior one, they are continuously trying to stop you right there, thinking you won't appeal. it's continuously appealed, you're in right to go back. You have a right to go back to when you first appealed it, claimed it.
All right, folks, that wraps up another time. Again, we love all the insight and knowledge y'all bring. The fact that you're bringing questions where it's just very obvious that you put in time studying what the regs say, studying what the M21 says, studying what other people have done. That is great. The more you do that, the more likely you are to get the benefits you deserve. We appreciate what we learned from you, and hopefully y'all are continuing to learn stuff from us. I love it more when Carol's a little more feisty.
Okay.
She must have had a good walk this morning or something. I don't know. But we're happy to be here with you guys, and hope you have a great rest of your week, and look forward to seeing you on the space next week.
Bye.